Chairman Blackburn, Ranking Member Schakowsky, and distinguished members of this panel, thank you for the opportunity to speak to you today about the pricing of fetal tissue. I'm currently a partner at the law firm of Warner, Norcross & Judd in Grand Rapids, Michigan, but for 13 years before entering private practice, I was an assistant U.S. attorney in the Western District of Michigan. I'm not a medical ethicist or a theologian. I do not represent any advocacy group on either side of the life versus reproductive rights debate, and I'm not here to advocate for any change in federal legislation. But as a former federal prosecutor and now criminal defense counsel, I hope to provide some value to this panel through objective legal analysis of the exhibits to determine whether the abortion clinics and/or the procurement business identified in the exhibits violated the statute. Based on my review of the exhibits, and I looked at this as if an agent had showed up at my office on any working day with these exhibits and asked me to examine them. But based on that review, I believe a competent and ethical federal prosecutor could establish probable cause that both the abortion clinics and the procurement businesses violated the statute, aided and abetted one another in violating the statute, and likely conspired together to violate the statute. In fact, for 5 of the 6 elements of the substantive offense, in my opinion, there is proof beyond a reasonable doubt. The only element where investigation is needed, and that would include, I believe, forensic accounting and analysis thereof, is whether the payments made by the research institutions that ultimately received the human tissue to the procurement businesses were valuable consideration or, alternatively, reasonable payments associated with the specific allowable services in the statute. With respect to the abortion clinics, in my opinion, the proofs more clearly establish that the compensation they receive from the procurement business, a price per tissue payment, is indeed valuable consideration, and as none of the identified services excluded from the definition were provided by the clinics. Now, prosecutors and jurors clearly prefer defined and established elements of the offense. 5 of the 6 elements of that offense are both clearly defined and established through the exhibits. As for the final element, valuable consideration, that element and those proofs are admittedly more nuanced. The statute itself defines valuable consideration by describing what it is not. It does not include reasonable payments associated with the transportation, implantation, processing, preservation, quality control, or storage of human fetal tissue. If valuable consideration is payment for something other than this exhausted list of delineated services, this element is also established. As for the abortion clinics, the marketing materials that I have reviewed clearly state that there's a financial profit from this partnership. Several of the exhibits indicate the procurement business pays for per the tissue, not a reasonable payment for the listed services. Therefore, the exhibits indicate, in my opinion, that these services provided by the procurement business through their embedded technicians and not the abortion clinics, therefore, that these payments appear to be valuable consideration. Indeed, they could be profits. As for the procurement business, it's my opinion that a much deeper analysis of the company's financials is necessary in order to establish the valuable consideration element beyond a reasonable doubt. Because the businesses do in fact incur costs associated with these delineated services, a forensic accounting would be essential to breaking down the company's financials. Just looking at the growth and looking at their revenue doesn't tell you whether they're profiting. And if they're profiting, in my opinion, they violated the law. I think there's some other theories here, although, that I think a prosecutor would pursue that may be more important in looking at the potential criminality of the businesses, the procurement businesses, and those are aiding and abetting and conspiracy. Based on my limited review of the exhibits reviewed and the strength of the substantive case against the abortion clinic, pursuing an aiding and abetting or conspiracy count against the procurement business rather than the substantive count may be a stronger theory of culpability. As I conclude, I would just say that I believe federal prosecutors take pride in protecting the most vulnerable among us. The ones I proudly served with in the Western District of Michigan did not shy away from the tough cases, and they put their personal politics aside when asked to evaluate cases for prosecution. Evidence or the lack thereof, not politics, should determine whether a U.S. attorney impanels a grand jury to investigate abortion clinics and human fetal businesses in their district. Again, I thank you, Chairman Blackburn and Ranking Member Schakowsky and the members for allowing me to testify today, and I welcome your questions.